Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a wild look at crazy laws that often make no sense. People arrested and strip-searched for violating a dog leash law, a crime to question another's chastity, state bans on sex toys but federal patents for them. You just can't make it up. We ask who did this and why. You just can't make it up, is how you will be left feeling. We will look at a variety of issues then from the realm of constitutional law, tort law, regulatory law, and sex-related laws to do a dive into the questions that surround our legal regime and create this wild and crazy situation of laws that make no sense. We will also look at the judiciary, specifically the Supreme Court and their often inconsistent and hypocrisy as it relates to shining ethics spotlights on others, but not themselves. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking exploration of wild laws. Before we run through our agenda and overview today, let's take a quick first pit stop on where the law goes wild. This brings us to the case of a nice sunny day, a man, his dog, the police, and prosecutors. This case comes from the 8th Circuit, and here are the facts. Sam the dog was wandering the neighborhood. Local police had seen the dog before and knew the owner. Sam returned to his home and went into the garage. Now the police were apparently not happy, and so they knocked on the door and wanted the owner to give his ID so they could fill out a criminal charge. Perhaps not surprisingly, the owner slammed the door in the police's face. But the next day they returned, this time with a warrant in hand. They arrested him for his leash law violation. Now, defendant got angry at the police station. Let's be honest, you can't blame him. But then the police made him strip, and the police proceeded to search his body, including visual exams of his anal and genital areas. He was not amused and filed a civil rights lawsuit. He lost a case, so appealed. Luckily, the absurdity that befell him found a receptive appellate panel, having not been so lucky with police, prosecutors, and the trial court. The Court of Appeals held as follows. Jones was arrested for failing to sign a summons and complaint arising from a leash law violation. Hardly the sort of crime to inspire officers with the fear of introducing weapons or contraband into the holding cell. In addition, officers had no other reason to suspect Jones was harboring these items. He was arrested early in the morning at his home and was not suspected of other crimes. Officers were with him every moment after they read him the warrant. They watched him dress and go to the bathroom, thereby eliminating any chance that he might have secreted a weapon on his person. It took all that to get to the basic point that the Fourth Amendment precludes jail officials from strip searching a person charged with violating a dog leash law. Yes, you just can't make it up. And so that gives us a quick entrance point to some of the fun stuff we will explore today. Let's discuss our agenda today to give you an overview of the substantive law we will touch in this program. We will cover a range of legal areas from constitutional, criminal, tort, family, sex, trademark, even to patent substantive legal regimes. In doing this, we will ask lots of fun and fascinating questions. Cheating spouses? Cheating can send you to prison in some places, but the right to extramarital sex is also a fundamental right in some courts. Wow, just wait and see that one. Do federal courts' rulings change depending on the state you are in as to whether you can be fired for cheating? What if you question someone's chastity? Be careful in some of our states. Fortune tellers make an appearance. Yes, you heard that right. Do in-state fortune tellers get preferential treatment to out-of-state fortune tellers? Stay tuned. We even look at some California cities that have outlawed loud cars on the Pacific Coast Highway. Imagine that, the greatest of American muscle cars cruising the Pacific Coast Highway, yet illegal in one city. Of course, whenever you start looking at crazy laws, you inevitably enter our sex law regime. How can it be that we have state laws that make it illegal to have too many sex toys, yet at the same time do we have the federal government giving patent son sex toys? Drugs also get legal regimes into crazy land. We will look at the federal government and its refusal to give marijuana-related trademarks, but the patent branch of the federal government issues marijuana smoking device patents. You really can't make it up. And finally, if we are to look at crazy legal rules, we have to stop at some point at the United States Supreme Court, where we can find legal hypocrisy abounding on rules. So let's get going, and we will start, of course, with some sex law legal regimes and quirky rules that you just can't make up. Where family law meets criminal law, cheating spouses, and the roller coaster of the law is where we begin. Let's start with Michigan here. Michigan Penal Code Section 750.30 is titled Adultery and Punishment. It says, quote, "Punishment. Any person who shall commit adultery shall be guilty of a felony. And when the crime is committed between a married woman and a man who is unmarried, the man shall be guilty of adultery and liable to the same punishment." End quote. A violation is punishable by a maximum of 4 years in prison and a $5,000 fine. And if a married man sleeps with a single woman or vice versa, even the unmarried party is subject to prosecution. Now, you watchers in California where I lie, you are lucky in that California has no such penal code here. But other states do exist like Michigan on this front, so watch out. So let's unpack this a bit in light of the Constitution's interpretation in various locations. The question we first confront is whether such a law is constitutional. Challenges based on privacy right of a person to engage in extramarital sex are mixed, it turns out, which leads us to a you just can't make it up moment. Some laws that punish adultery survive rational basis review given the state's interest in protecting family and preventing disease. Let's start with the case of Oliverson versus West Valley City. reported at 875 F-Sup at 1465 from Utah in 1995. Here is what that case was about. Plaintiff was a married police officer and had consensual sex with another woman, not a prostitute. It came to his employer's attention, and he was suspended for violating the anti-adultery and specific fornication laws of Utah. Plaintiff sued and challenged the constitutionality of the Utah fornication and adultery statutes. Specifically, the plaintiff argued that the Utah adultery statute violates a privacy interest protected by the 14th Amendment. The court traced the common law and ancient history of punishing adultery all the way back to ancient Rome. It then said, quote, "In essence, the plaintiff's claim of privacy is that the Constitution gives him an unfettered right as a married man to engage in sexual intercourse outside of his marital relationship." End quote. The court ruled, these employments of the criminal law to punish the practice of adultery support the conclusion that a wide variety of cultures and judicial systems have found adulterous conduct sufficiently injurious to justify some form of sanction, and to be conduct which society was not only unwilling to approve, but to attach an opprobrious criminal status. The American experience is somewhat different, but historically there is even greater support for the criminalization of adulterous behavior, and it concluded that the law did not, quote, support recognition of a privacy right to an adulterous relationship. The privacy interests protected by the Supreme Court and other federal courts' cases are inapposite to the conduct associated with adultery. End quote. The state could regulate it as follows. Adultery may lead to unwanted children and greater problems of child support. It may also lead to the destruction of a family and even serious violence. A state also has an interest in preventing disease, and adultery may be more deterrable than fornication. The adulterer whose liaison produces offspring may not have a protectable interest in the child. Adultery does not guarantee special status towards a child produced from the liaison. Thus, the state has a rational basis to regulate it as it does. Thus, the court ruled that the sanctions imposed on plaintiff were proper, and plaintiff's challenge and lawsuit was dismissed. You can see their citations to some other cases if you want to dive deeper into this. But before we see what happens in California, let's do a pit stop at some Supreme Court law on the right or private sexual behavior. This, of course, brings us to the 2003 Lawrence case from the Supreme Court. Here are the facts. After a report of a disturbance, Houston police entered Lawrence's apartment and saw him and another adult man engaging in private and consensual sex. They arrested them for deviant sexual intercourse in violation of a Texas statute forbidding two persons of the same sex to engage in certain sexual acts. The issue was whether the Texas law that criminalized sex by same-sex couples, but not identical behavior by different sex couples, violated the 14th Amendment guarantee of equal protection of laws. Before we answer it, let's listen to part of the oral argument.
But your position, as I understand it, is even if you take the narrowest view of Glucksberg, and even if you say there's got to be a positive historical sanction, that in fact there is no substantial historical evidence to the contrary, because A, the sodomy laws were not enforced against consensual activity historically, and B, they were not aimed at homosexual as opposed to sodomy in general. Is that your historical point? You say, even if I accept your argument, I should win?
Yes, Your Honor. I think, first of all, that the positive law, the law in the books, proves too much because it intruded right into the marital bedroom, and that the record of enforcement, which may be more informative, actually supports us rather than supporting the notion that this is something that can be regulated.
What do you mean by the record of enforcement? That what happened in this case was an accidental intrusion of the police. They didn't come into the bedroom looking for people conducting illicit sexual relations. They were there for another reason and happened to discover these men in that conduct. What do you mean by lack of enforcement? That the police have not gone around knocking on bedroom doors to see if anyone... I mean, this is not the kind of a crime the police go around looking for, but do you have any evidence to show that when they found it being committed, they turned a blind eye to it and did not prosecute it?
The evidence we have is the absence of reported cases discussing arrests for that kind of conduct.
Well, that's because it's an act committed in private, and the police respect the privacy of one's home, of one's bedroom, and so they don't investigate and find it. It seems to me what you would need is evidence that when the police discovered this matter, they said, these are not laws that we enforce. I don't see any evidence of that sort.
Well, certainly, it seems to us there's a significance to the fact that it has never been treated as, for example, drug use in the home has been treated. And people the police obviously do actively seek to infiltrate homes to find that kind of activity. It's been treated in a categorically different way. But perhaps I should turn...
Can you characterize it? I mean, the ACLU brief has a lot of evidence along this line. And it seemed to me they want to characterize it as saying that the history has gone exactly the opposite direction than what's been suggested. But if you go back to colonial times, really, the laws not only were different, but look at the prosecutions. And they did prosecute people for sex crimes, but they didn't prosecute people for same-sex crimes. And then if you go across the history, it's only recently that people have been prosecuted for same-sex crimes. But is that a fair characterization? What is the real record?
The argument about 19th century enforcement is that they didn't prosecute anyone for private and consensual crimes involving adults, that they worried about children, they worried about public activity, they worried about coercion, but that they didn't worry about same-sex or different-sex sodomy. Now, as to the equal protection point, which I think I should get to in my remaining time, this is a statute which, in addition to intruding into that area of important fundamental protections, limits its focus just to one small minority of the people of the state of Texas. It says that these specified forms of sexual intimacy called deviant sexual intercourse are illegal only for same-sex couples and not for anyone else in the state of Texas.
What about a statute that covered both?
Well, I think that would be unconstitutional under my first point, Your Honor. Right. I think this is a multiply unconstitutional statute because it does the second thing as well. It says
if the statute covered both, would there be an equal protection argument?
If there was a record of enforcement almost exclusively as to same-sex couples, I think there would be potential constitutional problems there. But the statutory language itself would not involve an equal protection problem of the same sort that we're dealing with here.
Mr. Smith, aren't there a lot of statutes like that? There are statutes in many states about adultery that don't cover sexual relations of one of the married couple with someone else of the same sex. Are they unconstitutional because of denial of equal protection?
I don't know whether statutes actually are written that way, Your Honor. The point I would make is that when a statute...
What about rape laws? There are rape laws that only apply to male-female rape.
That may be as well.
So there you heard tough questioning from Justice Scalia and others. In a 6-3 opinion, the court held that the Texas statute violates the Due Process Clause. Quote, their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. End quote. The three dissenters were Justice Scalia, Thomas, and Rehnquist. They would have ruled as follows. The Texas law, quote, undoubtedly imposes constraints on liberty. So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours per week in a bakery. But there is no right to liberty under the Due Process Clause, though today's opinion repeatedly makes that claim. The Texas statute undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable, the same interest furthered by criminal laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity, end quote. And the dissent of Justice Thomas picks up on our crazy law topic today. This is what he said, quote, if I were a member of the Texas legislature, I would vote to repeal it. Punishing someone for expressing his sexual preference through non-commercial consensual conduct with another adult does not appear to be a worthy way to expend valuable law enforcement resources, end quote. Those fault lines, thus, expressly lead us back to our adultery exploration. And as Justice Thomas said, laws that seem crazy on their face for legislators to adopt, all of which now picks up on Lawrence's ruling. So let's now see how this plays out in the adultery context. So as we move west several hundred miles to California and the Ninth Circuit, when it sees police officers engaged in adultery. Here we have the case of Perez versus City of Roseville, case number 15, 16430 from the Ninth Circuit in 2017. Here are the facts. Plaintiff Mims. Perez began working as a police officer. She spent the first 10 weeks of her probation period completing field training. Shortly after being released from the field training program, Perez separated from her husband. She then began dating another officer named Begley in the department, who also separated from his spouse shortly after he began working the same shift as Perez. Begley's wife then complained to the department. She alleged that Begley and Perez were having an extramarital relationship and suggested that they were engaging in romantic relations while on duty. She also alleged that her husband and Perez were engaging in numerous phone and text contacts while on duty. Internal affairs then took over. She was then terminated for unbecoming behavior. She sued and her case was thrown out. So what did the Ninth Circuit do? Here comes the roller coaster. First, the Ninth Circuit concluded that, if that was true, the firing would violate the officer's constitutional rights unless the adultery negatively affects on-the-job performance or violates a constitutionally permissible, narrowly tailored regulation. This would be a pretty similar test to that used for firings based on other constitutional rights, such as free speech clause rights. The panel started with the Supreme Court ruling from Lawrence that held the criminal convictions under the Texas law, which criminalizes sexual intimacy by same-sex couples, but not identical behavior by different-sex couples, violated the 14th Amendment guarantee of equal protection of laws. From there, the panel held that the state may not stigmatize private sexual conduct simply because the majority has traditionally viewed a particular practice, such as extramarital sex, as immoral. It held, quote, "Thus, without a showing of adverse job impact or violation of a narrow, constitutionally valid departmental rule, the Constitution forbids the department from expressing its moral disapproval of Perez's extramarital affair by terminating her employment on that basis." End quote. So far, so good, right? Utah said no, California said yes. But hold on.
Here is where it gets super interesting. Originally, the 3JUDGE panel said outright that Ms. Perez's claim could stand. But then one of the judges died, Judge Reinhart, an old-school liberal, and a new judge was substituted in, Judge Ikuda, and they changed the 2-to-1 split the other way, and so a rehearing petition now flipped the ruling. The new panel thus ruled that even assuming that Perez could establish at trial that she was fired, at least in part, because of her extramarital relationship with Begley, defendants were entitled to qualified immunity test. It was not clearly established that a police department cannot constitutionally terminate a probationary officer due to an ongoing extramarital relationship with a married officer with whom she worked, where an internal affairs investigation found that the probationary officer engaged in inappropriate personal cell phone use in connection with the relationship while she was on duty, resulting in a written reprimand for violating department policy. That is a narrowing for sure that takes the case the other way. And there was a dissent that was unhappy at the post-death change of judge. The dissent said, quote, "The more problematic concern is the substitution of a different judge following the post-publication death of the original decision's author. Judge Reinhart's vote and his opinion in this case were published before his untimely death." End quote. It goes to show how one judge can make all the difference, and that is why you just can't make it up.
Well, maybe as to being fired, you have a right to cheat and not be fired then. Maybe you do not, depending upon where you are. And remarkably, one judge perhaps. But let's take it a step further. If you do have a right and do it, then you can also be sued by the upset spouse. Let's look at that case. Here, Defendant Williams was sued for alienation of affection by the husband of the woman he allegedly had an affair with. He argued he had a constitutional right to consensually sleep with whoever he wanted to. It held that the state has a legitimate interest, indeed a substantial interest, in protecting the institution of marriage, ensuring that married couples honor their vows, and deterring conduct that would cause injury to one of the spouses. So can you be sued for having an affair by the aggrieved spouse? Alienation of affection and criminal conversation fall into the latter category. These causes of action do not demean the existence of any group of people. They apply evenly to everyone. Moreover, the state's interest in preserving these torts is strong. These torts deter conduct that causes personal injury. They protect promises made during the marriage, and they help preserve the institution of marriage, which provides innumerable benefits to our society. Thus, under Lawrence, our state's common law causes of action for alienation of affection and criminal conversation do not violate the 14th Amendment. So here's the rub of it. The Constitution protects the right to private sexual behavior between adults from state criminalization. But state tort law can sure punish you. And be extra careful in the military. UCMJ Article 134 states that adultery is extramarital sexual contact that can lead to punishment and discharge, and it includes genital, oral, and anal acts. But it's also not considered adultery if you are legally separated, somewhat relaxing the previous standards. The punishment? Fines, jail, discharge from service are all potential punishments. What if you do not actually have an affair, but you slander a woman's chastity? In one state, there's a law on the books that makes it criminal libel. Here is Oklahoma Criminal Statute 21-779. If any person shall orally or otherwise, falsely and maliciously or falsely and wantonly impute to any female, married or unmarried, a want of chastity, he shall be deemed guilty of slander, and upon conviction shall be fined not less than $25, nor more than $500, or by imprisonment in the county jail not less than 30 days, nor more than 90 days, or by both such fine and imprisonment. But a woman can slander a man's chastity under that law, as the law is a one-way street on gender. You can't make it up. Now we move from cheaters to fortune tellers. There is a Massachusetts law, you see the citation there on your screen. It requires that fortune tellers must be certified after 1 year of residency to practice their trade. The law says, quote, "No person shall tell fortunes for money, unless a license therefore has been issued by the local licensing authority. Said license shall be granted only to applicants who have resided continuously in the city or town in which the license is sought for at least 12 months immediately preceding." End quote. What on earth is the rationale for this unique law? Perhaps that traveling fortune tellers may lie, whereas resident ones will get the future fortunes correct. Or is it a way to keep the traveling gypsies out of town? Let's take a look. It turns out that this law has actually been litigated in part in the case of Talamo versus Providence Board of Selectmen in 1983 in federal court. Here is what happened. The plaintiff, a Massachusetts resident for the 28 years, was a professional psychic specializing in psychic consultation and advice. She ran her business in the city of Randolph. But then the plaintiff established a residence in Provincetown, where she had been a summer resident for 11 years, with the expectation that she would establish her business in the town. She applied for her fortune teller license. She was denied because she had not been a permanent resident of the city for 12 months in the city preceding the request. She sought an injunction so that she could earn her living. The plaintiff argued that requiring a period of 12 months residence as a condition to granting a fortune teller's license impermissibly burdens her right to travel, and the court agreed. Quote, "Though I acknowledge that there may be some role for the state to perform in requiring municipalities to license those who would hold themselves out to be fortune tellers, I cannot conceive of any compelling or even legitimate state interest in requiring 1 full year of residency in the municipality prior to the issuing of the license." End quote. Now the state argued that it intends to discourage transients from traveling from town to engage in the business of fortune telling. And the court said that was not good enough. The federal court thus ruled as follows, quote, "Because I find that there is no rational basis for the 1 year residency requirement contained in Section 185(1), and because I further find that the requirement is not reasonably related to the promotion of any legitimate state purpose, I must conclude that Section 185, I would not withstand scrutiny under the traditional standard of review." So there you have it. Ancient laws on the books that deny roving fortune tellers the ability to ply their trade get shot down. Now let's move from cheating spouses and fortune tellers to something all of us touch: the internet and Netflix. Here we will look at some internet laws protecting the internet media companies. This brings us to Tennessee. Here it is criminal to share subscription-based online passwords and use someone else's password on Netflix and other internet subscription sites. Here is the code. A person commits theft of services who intentionally obtains services by deception, fraud, coercion, forgery, false statement, false pretense, or any other means to avoid payment for the services. And the definition of services includes entertainment subscription service or other public services. What is the punishment for a violation? A fine up to $2,500 and up to 1 year in jail. The law says stealing $500 or less of entertainment would be a misdemeanor punishable by up to a year in jail and a fine of $2,500. Wow, use that $24.99 a month for too long and you may go to jail for a year. You just can't make it up. I'm now going to turn our attention to my backyard in Orange County, California, to the city of Laguna Beach. I don't want you to think I am only singling out other states. My state has more than its share of laws worth looking at. A California state law says 95 decibels is the limit for loud exhausts on cars, but police may exercise discretion if the car causes a nuisance. But the city of Laguna Beach decided anything above 80 decibels is a nuisance on the state PCH that goes through the city. Since January 2020, over 1,600 exhaust tickets have been issued against that American pastime of cruising muscle cars and bikes. This baffles us. Your car is legal under state law between 95 decibels. You drive it on a state Pacific Coast highway that the state paid for. But as you cross an invisible line on a map, you get a ticket for being too loud under the local law. That is one you just can't make up. Now we are going to move back to the realm of sex. This time it is not the act of sex, but the toys that go along with sex sometimes. Let's start with a law form, Alabama. This is the Anti-Obscenity Act of 1998. It says, quote, "Unlawful for any person to knowingly distribute, possess with intent to distribute, or offer or agree to distribute any obscene material, or any device designed or marketed as useful primarily for the stimulation of human genital organs for anything of pecuniary value." End quote. And further, any person who violates this subsection shall be guilty of a misdemeanor, and upon conviction shall be punished by a fine of not more than $10,000, and may also be imprisoned in the county jail or sentenced to hard labor for the county for not more than 1 year. Any person who violates this subsection shall be guilty of a misdemeanor and, upon conviction, shall be punished by a fine of not more than $10,000 and may also be imprisoned in the county jail or sentenced to hard labor for the county for not more than 1 year. So let's pause and recap. Distributing sex devices can get you in jail, but is it constitutional? Alabama had a near decade-long battle over this anti-obscenity distribution law as applied to sex toys. A plaintiff sued to invalidate the law, one Sherry Williams who owned an adult store called Pleasure Stores. Here is what she said as reported in the newspapers. Quote, "My motto has been, they are going to have to pry this vibrator from my cold, dead hand. I refuse to give up." End quote. That's priceless. Let's start with the district court. Alabama's interest in banning the commerce of sexual stimulation and autoeroticism for its own sake is an interest tied to social morality. Implicit in a legislative ban on the commerce of devices used for sexual stimulation and autoeroticism is disapproval of this type of activity. The reverse may also be true, that is, allowing the sale of these devices, which inherently implicates the state's regulatory channels, is an implicit condonation of this activity. Furthermore, implicit state condonation of certain conduct, which is created by the absence of state proscription, is likely to give some semblance of approval by the general public. Without question, social approval or disapproval, or the appearance of either, will affect the mores of a particular society. Thus, Alabama's interest in public morality is directly connected to what is sold with the state's tacit approval. Accordingly, this court finds that Alabama has a legitimate interest in prohibiting the commerce of sexual devices, but the court found that the sexual devices in issue are used by married individuals to aid their marital relationships and to facilitate or enable sexual performance with their respective spouses. Thus, there was no rational basis for the ban within a state interest inquiry. Now let's see what the 11th Circuit said. The state's interest in public morality is a legitimate interest rationally served by the statute. The criminal proscription on the distribution of sexual devices certainly is a rational means for eliminating commerce in the devices, which itself is a rational means for making the acquisition and use of the devices more difficult. It further held that Alabama did not act irrationally by prohibiting only the commercial distribution of sexual devices, rather than prohibiting their possession or use, or by directly proscribing masturbation with or without a sexual device. Quote, thus, we hold the Alabama Sexual Devices Distribution Criminal Statute is constitutional under rational basis scrutiny because it is rationally related to at least one legitimate state interest. End quote. Miss Williams tried to get the Supreme Court to take it, but they would not. Now, one last point. There was an exception for medical necessity. So if you can get your doctor to say you need a sex toy, then one can be distributed to you. But let's go to Texas now. Texas is a little similar, but it's a little bit different. Texas says it's illegal to have more than 6 sex toys. That's Texas Penal Code Section 4223. A person who possesses 6 or more, not 5, not 4, but 6 or more obscene devices or identical or similar obscene articles is presumed to possess them with the intent to promote the same. And so, per Texas law, a vibrator is deemed an obscene device. And that's the Villarreal versus State case at 267 Southwest 3rd, 204 page 206 in 2008. And so the result is having more than 6 means you're presumed to be engaged in some unlawful intent to promote the same and sell and do something else that violates the law. But if you have 5 or less, I suppose it's presumed to be for personal use, and so it's okay. So already you can see this massive discord in terms of yikes, just operating a sex store in the different states and liability, or perhaps traveling between Alabama and Texas. Check your luggage to make sure you don't have too many toys. Remember, Alabama, you can't sell them or you can go to jail unless it's for medical or educational purposes, but you can possess them. In Texas, you can have 5 but not 6. Can't make it up. You think that was an example of just can't make it up? Wait to see what happens when the feds get in on the sex toy action. Here's what the feds say about this. The federal government will actually give you a patent on sex toys. Yes, you heard it here. A patent on sex toys. So let's do a mini quick refresher on patent law so you can understand why that is. Federal patent law says that the government will issue patents for all useful, novel, non-obvious inventions. And that's from 35 U.S.C. Section 103. So the result is that federal patent examiners, upon the request of inventors, have issued patents for a whole bunch of sex toys. We have a list of some of them here. Self-remotely controllable wireless sex toy. And you can see there in the parenthesis, that's the patent number or application number, and you can look it up if you want online yourself. Also, patents have been issued for self-lubricating sex aids for an oscillating intercourse simulator and for a talking vibrator even. That's U.S. patent number 5992817. Now, I didn't show the pictures of them as this is a PG program, but you can find them on Google. But these sex devices, which are illegal in some states, they're actually deemed useful devices by the federal government worthy of patent protection, which again can only be given to new, useful, non-obvious devices. So while the feds say vibrators can be useful, states can send you to jail for too many of them. You just can't make any of this up. Yet hold on, it's getting more weird in a moment as we move from the realm of sex to drugs. Okay, so now we will stay focused on the feds and drugs. Marijuana is illegal federally, as you know, under the Controlled Substance Act. This has had some ramifications for trademark and patent laws in ways that are mind-bendingly silly. Let's start with trademark law. The federal trademark laws do not currently allow trademarks for marijuana categories of processed plants or medical marijuana. This is because marijuana remains illegal at the federal level. This means that you cannot get trademarks in those specific spaces. Now, a broader marijuana business that has a name and brand can get marks on their name in some contexts, and even on products such as clothes and the like, so long as they are limited to non-THC components or have certain CBD products at certain levels of CBD derivation. In short, it is super complex, and you need a trademark lawyer here to navigate getting a mark creatively within the federal anti-drug laws. For example, you may be able to get federal Class 34 for smoking materials and vapes that can apply to tobacco products and so pass through. Here is a recent case to consider, a case that went before the Trademark Trial and Appeals Board known as the TTAB. The TTAB denied registration for an oil dispenser for dabbing after deciding that the device was drug paraphernalia. The company seeking the mark argued that its product was not unlawful. Even if it was for use in dabbing, it did not violate Colorado state. But the TTAB rejected the argument because it violated, they concluded, the federal controlled substance laws. Hence, no trademark could issue. You can find that case as 2003 West, Law 3244416 from 2023. Now you can get state trademarks from state authorities where it is legal, which adds to the zaniness of all this. No federal mark, but yes, a state trademark. But what happens when you get to the other branch of the Federal Patent and Trademark Office, specifically the Patent Office? In the patent realm, no joking, there is no prohibition on marijuana-based patents as there is on marijuana-specific trademarks. Here are some actual marijuana device patents. Patent 9220294 on methods and devices using cannabis vapors. Patent 6328992B1 for a cannabinoid patch and method for cannabis transdermal delivery. Or Patent 6132762 for transcutaneous application of marijuana. Those are just a few. You can't make it up. No federal trademarks for the brand those products are sold under, but a federal patent can issue because the device is novel and useful under patent law. Here are a few. This one is from Apple. This patent is for a vaporizer device, and as you can see, it discloses a picture of a device that has substance placed in it that can be vaporized. As the patent describes, it is a chamber body to receive a substance that is vaporized and various embodiments that allow the vaporization of substances. And you thought Apple made only phones? But it gets even weirder when we look at some patterns that have been actually issued to the federal government. Here you can see a variety of inventors, and there you actually see a picture of the patent where the United States of America is represented by the Department of Health and Human Services has the patent. The patent is for cannabinoids as antioxidants and neuroprotectant, and the patent claim, as you can see reproduced for you, there is a particular method of treating diseases, which is achieved by administering a therapeutic effective amount of cannabinoids to people who have disease caused by oxidative stress. So cannabinoid patents can issue, but not trademarks. That's another example of how you just can't make any of this up. Of course, if we're going to have a law program looking at oddities in the law, in terms of actual laws passed and rulings by courts, at some point, we have to cast our eye to the United States Supreme Court being the highest court in the land. And here we can look at some remarkably backwards rulings that go both ways, depending upon who is on the receiving end of the ruling. Let's start with two of our Supreme Court justices, and I picked two to cover both sides of the political aisle, so this is not a political hit piece at all, and we see here that both of our listed justices received significant sums of money from publishers for book deals. Justice Sotomayor received over $3 million from her publisher Random House in royalties and advances. And Justice Gorsuch has a book deal too and has received over $500,000. But in a copyright case involving Penguin that appeared before them, They declined to recuse themselves in appeals to the court for review of lower court decisions. And you can see the case cite there. So far, so good. But what happens when a lower court judge finds him or herself in a similar situation? Let's answer that. This is the case of United States v. Wolf at 263 Federal Appendix 612 from the Ninth Circuit in 2008. Here are the facts. An indictment charged defendant with a corporate fraud scheme involving the inflating of his company's publicly reported revenue figures. He was convicted on all 18 counts. The trial judge refused to recuse himself even though he owned stock in a company, specifically AOL, that was connected to the scheme. The recusal rule at issue was Section 455b4 of the Federal Code that provides that a judge shall disqualify himself where he knows that he has a financial interest in the subject matter in controversy. And a financial interest includes ownership of a legal or equitable interest, however small. When the refusal to recuse went on appeal, the Ninth Circuit ruled that the judge did have a financial interest. According to the SEC, AOL aided and abetted securities fraud by Homestore and improperly inflated its online advertising revenue based on the Homestore-related transactions by at least $1.5 million in the fourth quarter of 2000 and $7 million in the first quarter of 2001. In this case, the judge's rulings could potentially have had a financial impact on AOL. Now, there is a line here in our other case noted there. For example, where a judge, as one of millions of stockholders in Bank of America, held a limited financial interest in the purported victim of a crime, it cannot be deemed a financial interest in the subject matter in controversy, because defendant's sentencing has no possible financial impact on judge. There, the defendant could not pay any restitution to the bank. But back on the other side of the line, the AOL case side, that required recusal. When the shoe fits there, recuse. But where the Supreme Court justices get millions in cash and ongoing royalties from a party before it's subject to potential copyright claims, no need to recuse. That's one for the books on how you can't make it up. If you want to do a deeper dive into Supreme Court hypocrisy on ethics, you can find my ethics program called Good for the Goose But Not the Gander, which looks at multiple different examples of this. We are just looking at a couple of them here to highlight how you just can't make up sometimes the oddities in court rulings. Now let's shift to Justice Barrett and the Americans for Prosperity. This situation involves a 501c3, Americans for Prosperity, and it spent over $1 million to help get Justice Barrett confirmed to the court. Of course, that is its right to engage in that conduct to do that, but that's a lot of money to be spending on lobbying efforts to sort of get the Senate behind the justice's nomination to put her on the court. But it worked, and she got appointed to the court, and, no sooner had that chapter closed and she's on the court, then a case comes up before the court called Americans for Prosperity Foundation versus Bonta. This is the case number 19-251 before the Supreme Court. Here's what actually was at issue in the case, because it's also somewhat important. Not just the fact that the same entity that just spent $1 million to get her put on the court was now before her. Let's even look at the underlying issue that was going on in the case, because it involved speech rights and soliciting contributions and giving identities of donors. And so basically, here's the issue. To solicit contributions in California, the state of California had a rule that those charitable organizations had to disclose to the state AG the identities of their major donors. Now, the state said having this information on hand would make it easier to police misconduct by these charities. And Americans for Prosperity said, no, we want to get money from people anonymously and don't want to hand over the names to the Attorney General. That's a fair First Amendment battle. Everyone's got a fair right to fight about who's right or who's wrong on that. But that was the issue. And so it's not just then the issue that there was $1 million spent to help get her on the court. But now we're looking at figuring out whether this very same entity may have to give up the identity of people who donated to that effort to that charity. So this tangled question was one that the court ultimately held that the demand is unconstitutional and that you can't force Americans for Prosperity Foundation to hand it over. But Justice Barrett didn't recuse herself. Instead, she actually participated in the decision of that question. And so the question I guess we raise, given the ethics framing question we're talking about here, is as follows. Is there really any question on a disqualification motion under the law we've looked at that other judges would have to recuse themselves in this kind of situation? We don't need to speculate. Let's look at a real case. We don't even have to look further than the Supreme Court itself. Let's take the case of Caperton versus A.T. Massey Coal Company, reported at 556 U.S. 868 from the year 2009. Here are the facts. There are multi-million-dollar donations to a lower judge's candidacy. The judge got onto the court. The judge then had a case pending, and the entity who donated was a party to the case. The other side said, hey, look, millions of dollars were spent getting this judge elected and put on the bench by you, so the judge has got to recuse. The judge said, I'm not going to recuse. The case went up to the U.S. Supreme Court, and so let's walk through what the U.S. Supreme Court has said about the propriety of this judge's behavior. This is a quote from the Supreme Court. The court has identified additional instances which, as an objective matter, require recusal. These are circumstances in which experience teaches that the probability of actual bias on the part of the judge or decision-maker is too high to be constitutionally tolerable. End quote. We're not just talking that is about Section 455 and did you violate a statute. Instead, the Supreme Court was looking to say, is this even of a constitutional dimension in terms of the importance of the ethics questions and the need to recuse? The court went on, quote, the difficulties of inquiring into actual bias and the fact that the inquiry is often a private one simply underscores the need for an objective rule. End quote. Recall, that's what we talked about earlier, but let's keep going. Quote, otherwise, there may be no adequate protection against a judge who simply misreads or misapprehends the real motives at work in deciding the case. The judge's own inquiry into actual bias, then, is not one that the law can easily superintend or review, though actual bias, if disclosed, no doubt would be grounds for appropriate relief. End quote. So here's what they said whether the person who donated the millions of dollars, whether those campaign contributions were a necessary and sufficient cause of State Judge Benjamin's victory, is not the inquiry. Similarly, we don't know if the $1 million Americans for Prosperity spent was the but for cause of Justice Barrett, getting the votes. But that doesn't matter either, the Supreme Court said when it was looking at this Caperton case. They went on much like determining whether a judge is actually biased, proving what ultimately drives the electorate to choose a particular candidate's a difficult endeavor, not likely to lend itself to a certain conclusion. This is particularly true, whereas here there is no procedure for judicial fact-finding, and the sole trier of fact is the one accused of bias. So what did the Supreme Court hold? It held the Constitution required recusal. The ethics situations were of such dimension here that the Constitution and due process mandated this judge be recused. And so this case went all the way up to the Supreme Court, which issued this ruling saying that the Constitution found the bias risk to be so great that the judge had to recuse himself. And the Constitution said this in part because there needs to be an objective, fair look at this, in large part, because there isn't even a proper mechanism for an individual judge to do it him or herself. Yet when they shine that ethics spotlight on others, they can expound fantastic rules such as the Justice Brandeis sunlight transparency idea, and they can speak from up high on the mount about the importance of ethics as they condemn this other judge justly. But when the light is shined on them, suddenly very different set of rules apply, as we saw with Justice Barrett, who didn't recuse herself and didn't face an inquiry from other members of the court. Of course, we now need to return to regulation of human sexual behavior, since that gives us much to look at and ponder. And this one again takes us to California, specifically the city of Walnut. Let's look at Local Code 1731. there is sheriff permission needed for a man to dress as a woman. No man or boy shall dress as a girl or woman without a permit from the sheriff, except for the purpose of amusement, show, or drama. But take the case of Hodge v. Lind, 88 F. Sup. 2nd at 1234 from New Mexico in 2000. There, a man was arrested at a county fair for wearing a baseball cap backwards as police thought it was a sign of gang affiliation. The federal court held that even under rational basis review, there was no rational basis for punishment impinging on his right to dress as he saw fit. Or in DeWeese v. Town of Palm Beach, at 812 F. 2nd 1365 from the 11th Circuit in 1987, the court held that a shirtless running ordinance had no rational basis and tripped right of personal appearance. And of course, this Walnut City Ordinance one is also crazy for another reason. It allows women to cross-dress, but not men. Go figure. That's an example of a law that needs to be repealed, probably. We started the program today looking at a crazy case involving our favorite for our friends, our dogs. And so it's fitting that as we close out our program on how the lodge just doesn't make sense, sometimes we go back to a case involving our dogs. This is the case of the Pasadena police and Toby the Beagle. Here are our facts. Officers see a dog, Toby, roaming the street. Now they recognize Toby as belonging to the Conway family. They see the dog return to the property, up driveway, and into the backyard. The police go to the home and knock. No answer, so they go around back and see the back door is open about 2 feet. The police decided to enter the home to seize Toby for running at large in violation of a city ordinance. So they enter and search all the rooms, closets, they look under beds, and they find Toby lying on a bed. They closed the doors so Toby could not go out again. But then Police and Humane Society returned and seized Toby for running at large. They took poor Toby to the pound. No, this is not a joke. You can read the actual case there as it is reported by the California Court of Appeal at 41 Cal App 4th at 167 Form 1996. The district attorney then proceeded to charge the Conway family with violating a city dog leash ordinance. The poor owners pled nolo contendere, and they received 2 years probation, and they only received Toby back 4 months after seizure. Aggrieved, the family took an appeal. On appeal, the appellate court held that the dog did not pose a danger, and there was no basis to justify dispensing with the warrant requirement and entering and seizing the dog. Unreal. This again can't be made up. Police, prosecutors, judges all participated in this one that led to a criminal conviction, and it took the expense and hassle of an appeal to get it undone. What happened to common sense? You just can't make it up. Well, I think it's safe to say that our exploration today shows that we get legal rulings and laws passed by state legislatures, which just cause one to ask themselves, how can this be? At some level, exploring these different areas of law and rulings allows us to recognize that it is hard for those who feel overregulated to even dispute that nearly all aspects of our lives are so heavily regulated that you get mind-bending conclusions at times. That said, the laws that may appear funky at first blush, sometimes a deeper rationale that may make them not so crazy as we saw, but a lot of them really do seem plain crazy. We saw a particular interest of legislators to regulate all aspects of human sexuality and sexual behavior, which led to a remarkable set of rulings that are hard to put together properly in a way that really makes coherent sense. You have a constitutional right to consensual adult sex, regardless of sexual orientation. We explored that in detail in Lawrence, and foreshadowing absurd laws, we had Justice Thomas say the law seems silly. Then we apply it in other contexts and saw adultery unravel. You can have sex privately and be left alone, but then you can be sued in civil court with the power of the state brought to you by way of tort law and judgment enforcement for doing it by an aggrieved spouse. Or you can be fired for engaging in adultery, or not, depending upon the situation. From sex to sex devices, we moved. We saw that vibrators and sex toys are illegal to distribute in some states. But in other states where you can have them, it can be illegal to have too many of them. But at the same time, the federal government will give you patents on them because they are useful inventions for society. You really just can't make that one up. We also saw the drug realm, the fact that you cannot get a trademark on marijuana-related brands, but you can get patents on marijuana devices. Even the federal government has a marijuana-related patent, so go figure that one out. And since we're talking about things that are hard to even square, it made eminent sense for us to walk through some of the Supreme Court's hypocrisy and rulings, where we saw in positions on recusal for bias that are simply impossible, basically, to reconcile. It's all in the eye of the beholder. And if we're getting that from the Supreme Court, then should we really be shocked that we get desperate rulings across courts throughout the nation, let alone legislative bodies? We also looked at Walnut's no cross-dressing ordinance. Yet other courts have said shirtless running ordinances are unconstitutional in that they infringe one's right to dress as they choose. We also walked a little walk through the Fourth Amendment jurisprudence of warrantless entries in the realm of police taking of dogs for violating leash laws. Even human strip searches for leash law violations. Can't make it up, but it's real. And perhaps that is one of the greatest lessons we can take from this program on the craziness of the legal system sometimes. We really need prosecutors and those with an enforcement discretion over all these endless laws on the books to apply probably a healthy dose of common sense as they decide to enforce these laws. Police, prosecutors, and even trial court judges, as we saw in those Fourth Amendment cases, allowed absurd situations to unfold that caused obvious financial and emotional havoc on people's lives, all over dogs and leashes. And that's one of the larger points in the program, because a lot of these crazy laws don't have to find an outlet in the litigation system, where we get more common sense supplied by prosecutors who take a step back sometimes and ponder what they're doing really makes sense. And some of them can be curtailed by the Supreme Court, just applying the rules equally to themselves that have to apply to other judges. So we can end here. Please be kind to our dogs. Please, if you're watching, I beg the prosecutor class out there, think before you indict on leash law violations. Thank you, and as always, if you want to reach out and share some crazy law stories, please email me. Thank you for watching.